Welcome to Cyber Law Now. It's a podcast where technology meets consumer rights, the law, and cybersecurity. Hosted by renowned attorney Steven Teppler.
Online privacy. Is there really such a thing in today's everything goes and everything gets posted digital world? Is privacy good or bad? And for who is it? When did we even start being concerned with privacy issues? What laws protect our privacy or take it away? What about our children? What if I told you that the last federal law protecting people from cyber intrusion was passed in the 1980s before there was even an internet as we know it? Or that there is no federal law expressly protecting your privacy? Or that the only federal law protecting children and privacy is now 20 years old and hasn't been updated? Or that our computerized election systems are still at risk, and that most of the laws passed since protect companies and not individuals? Or that companies want to keep you from suing them in court, even if they're responsible for privacy invasions or other cybercrime? Sounds a little paranoid, doesn't it? Want to learn more about cyber protection, laws, and how they affect you and our nation? Hi, I'm attorney Steven Teppler, and welcome to the Cyber Law Now podcast. I chair the cybersecurity and privacy practice at the Mandelbaum Salzberg law firm. Here at Cyber Law Now, we discuss today's cybersecurity, look at the legal issues, make you aware of them, and how they affect you and what you can do to protect yourself.
Malicious software.
Power.
The results are coming.
They say we are not prepared.
Spying, snooping.
It's scary.
We are absolutely and unequivocally thrilled yet again to have as today's guest for the third time, and I so appreciate him taking the time, retired FBI Special Agent Lawrence Wolfenden, who, as I mentioned, is a privacy, cybersecurity, and cyber forensics expert at the Silent Group in Sarasota, Florida. So, Lawrence, last time we spoke in our previous podcast, we discussed about what are some of the threats that are offered by open records, or what we call sunshine laws, where every public record or almost every public record or even a majority of public records are made easily accessible and requestable. And these days, because they're all digitized, they're super easy accessible and easily gotten by Joe Citizen. So we talked about some of the benefits as well offline, and I was wondering if you could give us and give our listeners a little bit of background as to why that is.
Sure. So, as we talked, it's a great thing that if I'm going to be moving into a new community, that I can take a look and see information related to taxing, related to potential rezoning issues. I might be able to see that there are problem neighbors because I can look at the various police call reports that have been there. I can oftentimes find out whether or not there are sexual predators that are moving into an area near me. I've got kids. People who have kids are going to be concerned about that and want to know who's moving in, if there's something there, or before they move somewhere else, they want to know that. Want to be able to find out what kind of arrangements might a politician have, or business arrangements a politician might have that may make you say, I do or don't want to vote for that guy. So there's a lot of good that can come from that. And then there's also the flip side of that coin. So there's the biblical admonition that he who has no sin, let him cast the first stone. And that resonates with a lot of people because we all recognize that at some point in our life we said something or did something that we shouldn't have done. Maybe we went off on a rant, we were angry, perhaps been drinking a little too much, all sorts of reasons why people say things that they regret. There's very few of us who manage to live our entire lives without making a mistake. And it's kind of interesting to think about this whole concept of privacy and the freedom of information on the internet, in the fact that 50 years ago, if I had done something that was embarrassing, it would be the people around me that might know and see it. And if it was really bad and really awful, there's always that, fail safe that I could move away and start over somewhere else. But today, kind of interesting when you think about it, my community for me to move out of is, it's everywhere the internet is, which is pretty much everywhere. So there's really not much of a place that I can move to in this country if I've done something wrong. So we're very much open to public scrutiny, and you can look at celebrities and politicians who have done and said things stupidly, and it costs them their career, their entire livelihood ends up going away because the whole world knows about what they've done, and there's no place they can hide. So it's good and it's bad, unless it's a legitimate mistake and you're the one, right?
Oh, yeah. So you have the ability to find everything out about everybody almost all the time and with relative ease and at low cost or no cost. This brings up some interesting aspects of privacy that in my teaching law students in law school, I keep repeating to them, and younger generations seem to not quite pick this up as quickly. But when in the old days, you and I remember that you'd have a holiday party, and some poor person who drank a little bit too much would wind up taking a picture of his butt on the copying machine, and the picture would get passed around and be a big joke, ha ha ha. And the picture would never get anywhere else except for maybe inside the organization or the company. The people responsible might get disciplined. Certainly, that would be a possible sanction. But today you have instant dissemination everywhere, so that same picture can be viral within seconds on the internet and forever have a negative impact on somebody's reputation or credibility, and to the point where people have even committed suicide because of what we now know of as cyberbullying. So I try to educate my students to tell them that you really have to be careful what you say and what you do. I have an old T-shirt that used to say, "Nobody knows you're a dog on the internet," because you could remain anonymous. And there was this picture of a dog at a computer screen and typing on the keyboard with his paws. But these days, I think the more proper thing to say is, everybody knows you're a dog on the internet, and many, many times over. And this kind of brings us to our next issue in talking about records and the ability to get information about people. And I want to talk about the Freedom of Information Act. There's a federal Freedom of Information Act that requires records held by the U.S. government to be disclosed on just a request by any citizen of the United States. And this is extremely broad. Certainly this is used in politics. It's used for any one of a number of corporate, personal, or legal reasons, even outside of what we call the discovery process in court. If you can't get it from discovery in court, you can make a Freedom of Information Act. It might take a little bit longer to get, but it's a different channel to obtain information. The FOIA authorizes federal agencies to withhold information when they reasonably foresee that disclosure would harm an interest protected by 9 exemptions. And after I name these 9 exemptions, Lawrence, I'd like you to talk a little bit about that. Then we'll go into some of the constitutional issues that are important. When we return, we'll discuss the FOIA exemptions. What are the reasons that the federal government can withhold information when you or anyone makes a request for information in the custody, control, or possession of the federal government? Welcome back to Cyber Law Now. I'm attorney Steven Teppler, and with me for the 3rd time, thank you so much for taking time out of your busy day, is Lawrence Wolfenden, retired FBI special agent. We're talking about the Federal Freedom of Information Act, which is that federal law which allows you to ask for information that the federal government has in its custody or control or possession. That said, the FOIA, which is the abbreviation for the Federal Freedom of Information Act, authorizes federal agencies to withhold information when they reasonably foresee that disclosure would harm an interest protected by one of these 9 exemptions. These are the exemptions. 1, information that's classified to protect national security. That's pretty clear, I think. 2, information related solely to the internal personnel rules and practices of an agency. 3, information that is prohibited from disclosure by another federal law. 4, trade secrets or commercial or financial information that is confidential or privileged. That means that when a bank or a hospital or some other financial institution is the subject of a federal regulatory investigation, that their trade secrets, their proprietary information, can stay confidential. Number 5, privileged communications within or between agencies, including those protected by, and I guess this is a little complex, but we might as well be complete, the deliberative process privileged, provided the records were created less than 25 years before the date on which they were requested. Attorney work product and attorney-client privilege, 2 privileges and protections that are native and used by attorneys to protect client information, pretty much, in client communications. Number 6, information that if disclosed would invade another individual's personal privacy. 7, we'll talk about that. 7, information compiled for law enforcement purposes that should remain confidential for a variety of reasons, and I'll let Lawrence talk about that. Exemption 8, information that concerns the supervision of financial institutions, as we said. And Exemption 9, geological information on wells. I do not think we're going to get into Exemption 9 in this podcast or perhaps any other, but perhaps, Lawrence, you can talk about FOIA and your experience with FOIA and exemptions during your tenure at the FBI and beyond.
Certainly. So the FOIA, it is a wonderful tool to be able to find out what information the federal government might have compiled about, in particular, where I've seen it used, and the largest interest is to find out what does the federal government, what does the FBI know about me? Not me, but somebody who's looking for this information. Sometimes it is about a third party. There's some time limits on when information can be withheld. And so as we approach the 25th and 30th and 50th, the different various anniversaries of the assassination of John F. Kennedy, there would always be a flurry of Freedom of Information Act requests coming through, wanting to look into the FBI's files on the JFK assassination. And Freedom of Information Act requests obtained information about people that were under surveillance by the FBI in the 60s and 70s. Martin Luther King, for example. John Lennon, I think, was one of those who had been under surveillance or investigation. And so there would be these FOIA requests that would come in seeking this kind of information. And I think that's a marvelous thing for our freedom as U.S. citizens, is that the federal government, the agencies, the government overall, the individual agents and employees of the government know that, hey, it is possible for the citizenry to take a look at what it is you're doing and what information has been collected. And if you're doing something wrong, you are going to be found out that you're doing something wrong. And I think that's a great check on the powers of the federal government. And in fact, I used to carry around a Freedom of Information request form with me that sometimes people would express an interest in knowing what the FBI knew about them, what kind of information the FBI was compiling, whether or not they were under investigation. And I could provide them this form and say, here, fill it out, send it in, you get it notarized, you send it in, and the FBI is required by law to respond. Now, it didn't mean that somebody got to come in and look at everything that might be there. You don't necessarily want somebody who is the subject of an ongoing investigation to be able to simply file a piece of paper and then go and see what is going on in the investigation of them that is current, and so that they can begin destroying evidence or intimidating witnesses or realize, oh my goodness, I'm not going to be able to prevent this, and they flee the country. That would be bad. You certainly don't want people to file Freedom of Information acts and requests and get information about you personally, and finding out private information that sometimes people will let the FBI know on a confidential basis. Somebody may be willing to tell the FBI, hey, I saw my neighbor, he drives in with a different car every week, takes it around back. It's red when it goes around back, and it comes out blue the next morning. I don't know. He might be stealing cars. To be overly simplistic about it, they might not want to have the neighbor know that they're the ones who was helping catch them. So there are some restrictions on it, but overall, it does provide a mechanism to keep the government in check. And personally, I think that's a marvelous thing. I'm a libertarian at heart, and I love the checks and balances that are built into our Constitution. It's all about, yes, we're giving up some freedoms and some power, but at the same time, we've got a lot of provisions to keep it from getting out of hand.
I couldn't agree more on that. Checks and balances are what we all learn in civics, even though I think most people don't take civics courses anymore. But I think for purposes of this discussion, I think I do want to talk about the exemption, the law enforcement exemption from disclosure. And I think that'll tie us into what you were just speaking. These are the reasons why law enforcement can discretionarily withhold information. One, if it could be reasonably expected to interfere with enforcement proceedings, certainly you don't want that to happen. Would deprive a person of a right to a fair trial or an impartial adjudication? That's a constitutional issue. C is, could reasonably expected to constitute an unwarranted invasion of personal privacy, and we'll talk about that in a bit. D is, could reasonably expected, if the information could reasonably expected to disclose the identity of a confidential source, or it would disclose techniques and procedures for law enforcement investigations or prosecutions, or would disclose guidelines for law enforcement investigations or prosecutions if, and there's always an if there, if such disclosure could reasonably expected to risk circumvention of the law. And the last one is, the disclosure might be withheld if it could reasonably expected to endanger the life or physical safety of any individual. Those are compelling reasons. When we return, we'll be speaking again with retired FBI agent Lawrence Wolfenden about not only the Freedom of Information Act and what it means. We'll talk about those pesky Bill of Rights amendments, those amendments which, when taken together, form the underpinnings of what privacy rights we do have in the United States. Welcome back to Cyber Law Now. I'm Steven Teppler, attorney with the Mandelbaum Salzberg Law Firm, and I'm speaking with retired FBI Special Agent Lawrence Wolfenden from the Silent Group. We've been talking about FOIA and exemptions and the benefits of open records and also their disadvantages. But right now, let's get back to privacy. And, Lawrence, there's no express federal law protecting our privacy. But in absence of an express statute, there is something called the Bill of Rights. And there are some amendments which permit us, or permit the courts, and permit individuals and citizens to have some privacy protections afforded to them. And let me start by looking at something which the First Amendment, which people pretty much don't associate with privacy. But if you listen to part of that amendment, it reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of people to peaceably assemble and to petition the government for a redress of grievances. This amendment sets forth the right to freedom of religion, speech, press, and assembly. Within this right is the implicit right of freedom of thought, which does have a privacy component. The government can't tell you what to think. Lawrence, what do you think?
You can't tell me what to think.
Have I tried?
No,
well, not today.
But
anyway.
Not today. So yeah, I think that's marvelous. I used to, in addition to the Freedom of Information Act request that I carried around, I also always had available a copy of the Constitution, and it was dog-eared to the Bill of Rights. Again, I'm very strong advocate and believer in that those initial 10 amendments are so critical to what makes this country great.
That's true.
And
That's
why
true.
I wouldn't want to live in anywhere else. And yeah, it's the right to peaceably assemble, the right to be able to sit with and meet with and talk with and gather with like-minded individuals without fear of the government coming in and saying, oh no, you're associating with an undesirable element. You're associating with people who we don't like, and that they're malcontents or whatever.
Mm-hmm.
The government, I mean, the history of tyrannies show that the first thing that a government that wants to maintain control of their people is to keep like-minded people from associating with each other if those like-minded people are opposed to the government, because they foment dissent.
And so, let me stop you there, because you, when we look at the First Amendment and you look at privacy and you look at the right to peaceably assemble, the first thing that comes to mind is, is that really privacy? I mean, Teppler, how can you even say that? Okay, well, talk like a lawyer and say, well, think of it this way. The right to peaceably assemble means that the right to peaceably assemble in private as well, and to have your own private thoughts. So that's preventing what we call, in some ways, an intrusion upon seclusion. The government has no right to tell you that you can't. And assemble doesn't mean in the park, to have a demonstration. It also means to assemble in your place of worship, or in the basement of your home, or in the living room of your home, to discuss politics, for crying out loud. Let's go to the Third Amendment. And this is also, it's interesting to mention, because this also reflects that sense of no intrusion upon your seclusion, upon your private space. So the Third Amendment in part says, no soldier shall in time of peace be quartered in any house without consent of the owner, nor in time of war, but in a manner to be prescribed by law. Which means the government can't force people to house soldiers in their homes. You can't occupy people's homes. I mean, not unless you have a really serious, or what we call an exigent circumstance, such as, a natural calamity, an earthquake, or a flood. And even then, there have to be prescribed procedures for that. What I'd like to do is go to the Fourth and Fifth Amendments in the time we have left, and say the Fourth Amendment, and talk about the Fourth Amendment first, which is basically the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. Basically, and generally, search and seizures, arrests, etc., need to have a warrant issued by a court or law enforcement official for a justifiable reason. So, Lawrence, why don't you talk a little bit about this and privacy in the digital realm, and what effect does that have on our privacy?
Well, the Fourth Amendment, interestingly, while it is established to prevent government overreach, I always associate it in my own head with the warrant process. That it, by establishing and making a requirement that a warrant had to be gathered to be able to go into somebody's house, into somebody's computer, or obtain certain records that somebody might have, that it's there to protect the privacy, but by virtue of being there, Congress and the courts set up policies and procedures to where you gather or obtain the warrant that allows you to go into those areas, the people's houses, the people's computers, and records, to get that information.
Here's a question I have for you that many people ask me, clients ask me, and students ask me all the time, and that is, if you have evidence of a cybercrime being underway, or that one that is imminent, that might happen at any moment, and the only way you can find out the identity of that alleged criminal, that cyber criminal, would be to go to an email hosting company like Google, an ISP, an internet service provider, Microsoft has Hotmail, et cetera, or Yahoo even, and you need to find out who sent this and who is responsible for this. There are a couple of laws that have been enacted in recent memory that affect or that guide what the government can do or cannot do. And that also kind of plays into the Fourth Amendment a little bit. And that is, what about the Stored Communications Act? And then what about the Patriot Act? And does the Patriot Act, I guess, as a follow-up, kind of water down your privacy rights?
Right. So if the concept of having my personal, my house, my person, my papers are private unless government has a warrant. Well established, a warrant needs to be obtained. But then you have these email hosting providers that are actually third party. So there's that constitutional issue of how can I claim that that these are my personal private records and the government shouldn't be able to access them if I've already given them over to a third party, and some third party, Google or Yahoo or AOL or whatever email hosting provider has those records, has those letters that I've done, or the person I've sent those emails to. If I've given up those letters and those papers, those documents, to somebody else, then how can I claim that it was private? And the government, as an FBI agent, if I knew that you were communicating with somebody else, and I'd like to see what those communications are, I could come ask you. But if you're trying to hide something, you're not going to give them to me. Or I could go to the other person that you were writing to and see if they would give it to me. There's no constitutional prescription on me getting it from those people, asking them to provide it. I could go to the email hosting provider and see if they would give it to me. But there are statutes in place that prevent them from just turning that information over. And the courts and laws have been written that basically say, you know what, that is such private information. It's your personal communications. They're just electronic. In order to get that, the government is still going to need to generate a warrant, just as if they were trying to come into your house. They have to have a warrant. They're going to have to establish probable cause and get a judge to agree, yes, you have the right to get those records. But there are the circumstances, as you alluded to, that are exigent circumstances, something that's an emergency. Somebody has been kidnapped or is in danger of being kidnapped or in danger of being harmed. And the government believes, the investigators believe, that if they can obtain the information about somebody who sent an email or a text, maybe it's a threatening text or a threatening email that says, I'm going to do something bad to you, that the government can go to the email provider and say, hey, this is an emergency, and we'd like to know who it is that actually sent this information. We'd like to read their other emails. And that exigent circumstance, it's interesting. Some people don't realize that it's not for the FBI to come up to the email provider and say, this is an emergency, give me those records. What we have to do is, what the FBI has to do is go to the email provider and say, here are the circumstances. We believe it's an emergency. Here's the facts related to it. And then the email company, the email provider, they look at it and they decide whether or not they believe that it's an exigent circumstance, at which case they can make this emergency disclosure back to them. So it's not even that the FBI can go in and flash their badges and force the information out. It's still this other party has the ability to say no. They can't. They could refuse. They absolutely could refuse to give it over. They can say, and I've seen it happen, where they say, we just don't see this as an emergency. We don't see where what you're saying is correct. And they don't give the information over.
So law enforcement just can't grab your digital stuff without some sort of reason. And that's become pretty clear. Let's talk briefly about the Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself. Generally, it means you can't be forced to testify if you believe your testimony would incriminate you. Typical law and order stuff. Let me give you an example of how that turns on its head when it comes to computers. If you have a password on your computer and you use it to encrypt your information, in most courts, that you can't be compelled to disclose your password because that would be considered testimonial. That sounds kind of understandable. But listen to this. If you use a biometric, a fingerprint, instead of a password or passphrase to encrypt, and fingerprints don't encrypt, biometrics don't encrypt, they unlock, that is not considered testimonial, and you can be forced to give your fingerprint as, just like you can be forced to give your DNA, because that's non-testimonial information. It's not a secret. A biometric is never secret. I just wanted to add that because that's a twist of the law that still may be resolved with refinement in the future. Well, we've been to law school. We've been to law enforcement school today with retired FBI Special Agent Lawrence Wolfenden from the Silent Group. We've learned about FOIA. We've learned about constitutional law, the First Amendment, freedom of press, the Third Amendment, the right not to have the military just decide to take up residence in your house at the government's insistence. And we've learned about the Fourth Amendment, which is searches and seizures without warrant and arrests, and the Fifth Amendment, the difference between biometrics and passwords. And this is a continuing and evolving area, and we'll talk about more as we move along with Cyber Law Now podcasts. So we've seen today that there are laws that actually help protect our privacy without there being an express federal statute that says your stuff is private and nobody can touch it. We know that there are constitutional amendments such as the Second and the Fourth, and the first, the third, and the fourth, and the fifth that have components which help establish some privacy protection for American citizens. We've been to law school and law enforcement school today with retired FBI Special Agent Lawrence Wolfenden of the Silent Group. We've learned about the Federal Freedom of Information Act. We've learned about some constitutional protections that help us with our privacy issues, although we don't have an express federal privacy statutes. But we now know that there are some legal protections that can help make sure you and your children and your loved ones are safe from bad actors and criminals. Thanks so much, Lawrence, again for this third segment of privacy and cyber law, and for joining us today. I hope to have you back on Cyber Law Now soon, and thank you, our listeners, for your interest. Don't forget to hit subscribe and get all of your cyber law podcasts while you sleep. Share them with your friends. If you have a cyber law subject you want to hear more about, contact us. Join me next time for Cyber Law Now. I'm Steven Teppler, attorney on the Cyber Law Now podcast.